On April 14, 2025, Tamar McIntyre, a rapper known as Tay K, was convicted of murder for a second time in Bezar County, Texas, and sentenced the following day to 80 years in prison. This conviction arose from an April 2017 incident in San Antonio in which Mr. McIntyre shot and killed 23-year-old photographer Mark Anthony Saldivar during an altercation outside a Chick-fil-A restaurant. Mr. McIntyre committed this offense while actively evading law enforcement, having cut off his ankle monitor in March of 2017 to escape house arrest for a prior offense. At the time of the 2025 trial, he was already serving a 55-year sentence following his first conviction on July 23, 2019, for murder and aggravated robbery. Following the verdict, defense attorney John Hunter filed a statutory motion for a new trial pursuant to Texas Rule of Appellate Procedure 21, alleging severe constitutional due process violations under the 14th Amendment and the due course of law provision of the Texas Constitution, Article 1, Section 19. Mr. Hunter argued that the prosecution committed misconduct by withholding critical discovery materials in violation of the Michael Morton Act, codified under Texas Code of Criminal Procedure, Article 39.14. Among the withheld materials were co-defendant plea details and access to criminal database records, which the defense contended fatally undermined its ability to cross-examine the state's primary witness. On May 23, 2025, a hearing on the motion for a new trial was held in front of Judge Stephanie Boyd in the Bexar County 187th District Court.
Court is calling 2019 CR 12495, State versus Tamar McIntyre. Could I have parties announced?
State, John Hunter for Mr. McIntyre, Your Honor.
Are you Mr. McIntyre?
Yes, ma'am.
All right. State defense has filed a motion for new trial. Have you had a chance to review that?
I did review.
And are you ready to proceed on it? All right. So the court has read the motion for new trial. I think the motion for new trial clearly has the defense's arguments in it. So with regards to number one.
Yes, Your Honor.
Any rebuttal?
Yes, Your Honor. And that, I believe that's the NCIC, TCIC argument, I guess, of the offense. Our position is that we did make it available during court proceedings, and they had access to the actual TCIC, NCICs. And through our understanding of the policy is that we can't allow them to duplicate or keep or make copies of, and that's by, I believe, state orders on that. So that's our position on that front.
All right.
Megan Dowling for the state. Just briefly, if I could address that point, and I want to reiterate the arguments that I made at trial, which is that 411.083 of the Texas Government Code is what governs the dissemination of the criminal histories. They were provided to Mr. Hunter, and that's stipulated to in the motion. He states that the state did provide him those. And so that is our position. It would have been a violation of law to allow him to keep them or to reproduce.
All right. And then defense, because it's your motion for new trial, I'll give you the final response with regards to the state's answer to defense's number one.
Yes, Your Honor, and forgive me. I did not prepare to proceed today. I came to court because the law requires me to show you the motion within 10 days.
Yes.
And so I haven't, I wasn't anticipating actually discussing the merits of it today, but if the court wishes us to proceed with that, I mean, our position with respect to the NCIC argument is fairly simple. We cited you case law, which the courts have addressed this subject matter before and have recognized that it is covered by the Michael Morton Act and that it would be required to be produced. As a practical matter.
Well, you're saying produced, but the state is saying that they did produce it. They just didn't allow you to copy it or leave with it.
It was given to us on the first day of the trial. And in the process of trying to make use of it and note it down, we got into an argument about whether or not we'd be able to photocopy it, which we immediately brought to the court's attention. We had an argument in which the court concluded that we were not entitled to copies of it, which we respectfully disagreed with.
Does the law say that you are allowed to make copies?
I believe that that is what those cases that we have cited for stands for, that proposition, that it is producible under the Michael Morton Act in all ways that other discovery is producible. The state's contention that there is a statute that privileges it from disclosure, I think, is being misinterpreted.
Okay, they're not saying, and correct me if I'm wrong, they're not saying that it doesn't prohibit them from disclosure. they're saying, yes, we do disclose it to you, but you're not allowed to copy it or leave the courtroom with it. Am I misinterpreting what's being said?
That is their argument. Yes, Your
All
Honor.
right, so-
We just disagree with that position. I don't think the law supports it. And we also would maintain, as we maintained at the trial, that as a consequence of, well, let me rephrase that. To the extent that there is any countervailing or overarching privilege that would run afoul of the case law that we've cited, Your Honor, about its discoverability, or that would limit our ability to use it from how we would otherwise be entitled to use discovery. I would maintain that that privilege is waived by two separate independent actions. The first is this isn't a situation where we're trying to snoop on these people's lives outside of the context of defending Mr. McIntyre. He is indicted. The state made that decision. When the state or the government have a privileged interest in the privacy of certain sensitive information, and they elect to indict someone for a criminal offense over it, then they can't be in the position of being able to still hold on to that privilege. They waive it. Secondarily, they have run the TCIC, NCIC for these individuals, which is the triggering event. The database is curated not by this office. It's curated by the Texas Department of Public Safety and the FBI. They query that database. They are only allowed to query that database if they have a good faith reason to do so in the execution of their duties and responsibilities as members of the district attorney's office. They can't just go pull NCIC, TCIC on you or me because they're upset with us, or they for a petty
You're
difference.
saying that they were upset with somebody, that's why they...
No, I'm giving this as an example. I have had cases in the past where I have defended policemen who were accused of improperly querying the TCIC, NCIC database for petty reasons.
So we're not saying that any NCIC, TCIC was queried without a good faith basis.
No. In fact, quite the opposite. We know that there was a good faith basis because this is the TCIC, NCIC for their witnesses. And Brady versus Maryland, and every case that has come since it, says that they have to give me that information. That
Okay,
is a
so
requirement.
then
So-
the main argument, and so let's stick with what the argument is. And if I'm wrong in interpreting what's being said by both parties, the argument is not that you received the information. Your sole basis is that you should have been allowed to photograph or reproduce or take the item, the NCIC, TCIC with you.
We
Is
wanted,
that your?
we wanted to be able to use it in every single way that you can use.
No.
the
My
paper.
question, I'm trying to get to specifics. The specific is,
The
well,
specific,
let me start with this. Number one, was the NCIC, TCIC provided to you? Yes or no?
it was handed to me and I had about 10 minutes with it before we had to turn it back over.
Okay, so now with regards to it being handed to you, then it was handed to you. The next question is your sole objection or request for a motion for new trial with regards to point one is that you were not allowed to photograph it or take it with you. Am I correct in that?
The contention is twofold. The first problem is that we were not allowed to photograph it, take it with us, duplicate it in any way. We had to turn it
Okay.
back over. And as we explain in our second argument, that became an acutely problematic issue because we were unable to make use of that information to respond to the state's argument that for authenticity reasons, we were not entitled to offer Joanna Reyes's prior judgment of conviction at sentencing.
Mr. Hunter moved for a new trial on the ground that the trial court unconstitutionally restricted the defense's ability to copy and retain the criminal history records of the state's primary witness, Joanna Reyes. Under the landmark Supreme Court decision in Brady versus Maryland, the prosecution bears an absolute, non-delegable constitutional obligation to timely disclose all exculpatory and impeachment evidence to the defense. This duty encompasses law enforcement records maintained in the National Crime Information Center, known as the NCIC, and the Texas Crime Information Center, known as the TCIC, to the extent that those records bear on the credibility of a witness. The constitutional foundation for this requirement is reinforced by the Confrontation Clause of the Sixth Amendment, which guarantees a defendant the right to meaningfully cross-examine witnesses presented against him. In this case, the prosecution provided the NCIC and TCIC records to Mr. Hunter only on the first day of trial, within a 10-minute window, and strictly prohibited him from photocopying, photographing, or retaining them in any form. Because these records were necessary to introduce prior convictions for impeachment purposes under Texas Rule of Evidence 609, the defense argued that it was rendered functionally unable to challenge Ms. Reyes before the jury. Mr. Hunter therefore maintained that a brief view-only inspection did not satisfy the state's statutory disclosure obligations, and that the artificial restriction on access constituted a violation of his client's constitutional right to a fair trial.
All right, so let's start with this point. First point, state, when was the NCIC TCIC given to defense?
Prior to jury selection, Your Honor.
And the prior to jury selection, was this the NCIC TCIC that was given to the defense prior to the jury selection? Do you remember which witnesses those would have been?
Was for all witnesses listed in the discovery.
So would that all also have included Joanna Reyes?
That's correct, Your Honor.
So you're saying that was given prior to jury selection?
It was, Your Honor.
All right. So it's the court's understanding that for purposes of cross-examination, NCIC, TCIC are considered timely if they're given before cross-examination, but my understanding is that the state gave it to you prior to jury selection. So the first question is, were the NCICs, TCIC given to the defense prior to jury selection?
A stack of paper was handed to me.
No, my question is,
I want to make sure the record is clear.
I want
because
the record to
first
be
question
clear
is
too.
not accurate. I mean,
I want to know, they're saying that they gave the NCIC, TCIC of all witnesses to you before jury selection. And it seems your main complaint in here is regarding Joanna Reyes. So my question for the defense is whether or not the NCIC, TCIC, for all the state's witnesses, were they given to you prior to jury selection? Then we can handle your other point.
the word given is not a word that I can address in that.
Were they handed to you?
I held them in my hand for a few minutes. I didn't have an opportunity to digest their contents fully. I wasn't allowed to copy them. Almost immediately afterwards, I was told that their position was going to be that I wasn't going to be allowed to copy them. I had to instruct the
Okay, so
staff.
here's the thing.
Let me just finish real
No,
quick.
no.
You want-
No,
I need to-
because
I
no,
need to
stop. We're taking it one point at a time. My first question is, were they given to you prior to jury selection? It seems that your answer to that is yes. Then we'll get into what you were not able to do with them. So the record is clear. My understanding from you is that witnesses who are going to testify in the state's case in chief, their NCIC, TCIC was given to you prior to jury selection. Now that that's been established, then the next question becomes, what were you able to do with the NCIC, TCIC that was given to you?
Nothing.
All right. So you said, were you allowed to elect, because in your motion, you say you were not allowed to electronically duplicate. Were you allowed to electronically duplicate them?
No,
Were you allowed to copy them?
no,
Were you allowed to photograph them?
no.
And I'm taking that straight from your motion. So state, with regards to the NCIC, TCIC that was handed over to the defense, you're saying it was all of your witnesses in the case in chief.
Yes, Your Honor.
The defense is saying they were not allowed to electronically duplicate, copy, or photograph any of the NCICs, TCICs. Now, why were you not allowing the defense to either electronically duplicate, copy, or photograph the NCIC, TCIC?
Because I didn't want to be charged with a misdemeanor offense.
All right, and where are you obtaining that from, the fact that you would be charged?
Your Honor, I previously stated, there are two subsections of law that govern the dissemination of criminal histories. The first being Title 28, Part 20 of the Code of the Federal Regulations, and then the second being 411.083 of the Texas Government Code.
All right, so the state is saying that they could not allow you to electronically duplicate, copy, or photograph based upon Title 28 of the Federal Code and also Chapter 4 of the Government Code. What is your response?
Several things. First, we do not believe that those provisions prohibit a defense lawyer from taking possession of the criminal histories for the purposes of defending a man at trial. That is not the purpose of those laws. That is our position. Secondly,
All right, let me just stop you for a moment. When you say taking possession of it, what do you mean by it doesn't prohibit you from taking possession? What is your definition of taking possession of the NCIC, TCIC, as you see it?
a lawyer should be able to keep the paper with him for the course of the trial so that it can be read, it can be understood, and it can be researched further.
All
And
right.
none of those things were able to be accomplished. I was unable to finish reading the histories. I was unable to digest their contents or understand them or make any meaningful use of them. I was unable to copy them so that I could do that when we weren't in court at recess at any point.
All right, so when you say taking possession, you mean keeping the paper. And when you say keeping the paper, for the record, we're talking about the NCIC, TCIC. When you say keeping the paper, do you mean leaving the courtroom with the paper?
I mean, right, I could not leave the courtroom with the paper. I could not photocopy the paper. I could not make use of the paper. And we had to give it back at the end of the day or at some point during the process. I wasn't able to read or digest the information while I was participating in my other roles as being Mr. McIntyre's lawyer. Counsel said it was handed prior to jury selection. That sounds right. I don't have independent recollection of the day, but we were involved in jury selection for all day and into the evening. It was a lengthy process. And so there was not an opportunity to make any use of it.
In response to the defense's challenge, prosecutor Megan Galloway contended that the defense had no right to photocopy, photograph, or electronically duplicate the NCIC and TCIC records. The state's position rested on Title 28, Part 20 of the Code of Federal Regulations, and Section 411.083 of the Texas Government Code, both of which impose strict limitations on the dissemination of criminal history record information to protect the integrity of secure government databases. Under Section 411.085 of the Texas Government Code, the unauthorized dissemination of such records constitutes a misdemeanor offense. Ms. Galloway argued that in restricting physical reproduction of the records, she was acting in compliance with these privacy statutes, which she maintained operate independently of standard trial discovery rules. However, even accepting the state's framing of its obligations under those provisions, there remains a meaningful distinction between protecting the security of government databases and denying defense counsel the functional ability to use lawfully disclosed materials in the course of trial preparation. The statutes cited by the prosecution were designed to prevent the unauthorized distribution of criminal records to the general public, not to cover a witness from constitutionally mandated cross-examination. Accordingly, there is considerable merit to the defense's argument that these privacy provisions were never intended to prohibit a defense attorney from taking working possession of criminal history records for the sole purpose of preparing to impeach a witness at trial. By imposing a 10-minute view-only restriction on the eve of proceedings, the state effectively neutralized a core component of the adversarial process.
Also, I can just say, Your Honor, in both federal and state trials that I have participated in, I have never had this issue come up before. I have had prosecutors with the Department of Justice hand me the Jenks material, which would include the criminal history material, prior to the commencement of trial. I understand that the Jenks Act similarly narrows that compulsory moment of disclosure to when the witness is passed for cross-examination, but almost every judge in the United States has recognized that while that law may be that that's when it must be produced, that isn't a fair system. It doesn't provide for meaningful cross-examination.
Okay, then somebody needs to change the law. And counsel, I'm sure as you're aware, sometimes people do things that are inappropriate legally, but they do them and nobody ends up saying anything. Nobody ends up charging anybody within anything. But in this court, I'm just here, Mr. McIntyre, to listen to arguments and follow the law. That's my role here as far as this case is concerned, because the jury trial is the parties that made the decision.
But Your Honor, what I'm saying is I don't think that the law has to be changed because I don't think that the law comes to this conclusion. I think that the conclusion the state's asking you to draw from it is not what the law means in its full synthesis, and that the court's responsibility is to allow the lawyers to be able to provide a meaningful defense to the defendant, which includes having access to the impeachment material that is involved in the case. And in particular, Your Honor, what I think we also need to draw clearly is that this isn't just about the general frustration, although there is that general frustration of not having the ability to use that information and have it on counsel table's desk at the exact time that we are in cross-examination or preparing the evening before with that information. Those things all occurred. And so there is a global harm there. But the specific and acute harm, and the reason why a new trial should be granted in this case, is because, as ground two establishes, we have a situation here where the prosecution has misrepresented the criminal history of its most important witness and did nothing to correct that record, even though the very documents we are talking about here, the TCIC, NCIC records, are the proof that it was a misrepresentation. And so that's what really ties this thing together, is that the TCIC, NCIC is being used as both a shield and a sword against the defense. And that's not its purpose. That's the bigger overarching issue here. And certainly with respect to both constitutional law as it pertains to what due process of law for a criminal defendant means, and in terms of the full synthesis of why these laws exist and what their purpose is and how those things are supposed to operate, it simply is not the case that the court could not authorize the defense to have access to that information during the proceedings. And we were amenable then, we told the court we were amenable then, that we would have taken it under protective order. But that option was not explored.
All right, so with regards to the defense request for a motion for new trial under point one, that will be denied. Point two, misstatements of the prosecution in closing argument. What misstatements?
The the state in closing argument told the jury that Joanna Reyes should be credited with belief because she had abided by the conditions of her bail on her tampering case, on her capital murder case, and had not done anything illegal, had not broken the law. And we quote the argument verbatim in the motion. We approached and explained that's just simply not true. Joanna Reyes, after she was charged in Mr. McIntyre's case, and after she entered her plea of guilty to tampering with evidence, and after her sentencing was held at abeyance and postponed pending the outcome of Mr. McIntyre's trial, she went out and obtained criminal conviction for the felony offense of credit card and debit card abuse. She was also arrested and charged with unlawful carry of a weapon. That case was dismissed because she pled to a different offense. We've included all of those records that we've obtained from the Harris County clerk as exhibits in the motion for new trial, which we'd ask that the court receive. We also made a bill of exception at the trial of the judgment of conviction for credit card and debit card abuse at the sentencing phase of the trial, which we'd ask the court to take under consideration as well. There's just no question that the state told the jury something that isn't true. Now, listen, I think Jason Garahan is a very reputable, honest, and hardworking prosecutor, and I have immense respect for him. I don't know why they said this, but it's just not true. It's objectively false.
All right, response.
Well, Your Honor, with respect to the statement, I trust that their motion states what I said during argument, which is closing argument during the guilt innocence. And what it may be, slip of the tongue, or the fact that I misstated that Joanna Reyes had I don't know exactly what was said, but alluded to the fact that she didn't break her bond is something that can be argued that was done by mistake on my part. That may be, but the fact remains is that defense counsel knew about this and did not bring this up during her cross-examination. And the fact is that the jury is well aware of her credibility, or credibility issues, if you may, of her being a co-defendant to a capital murder, and of her testimony that she gave during the portion of guilt innocence. And touching on the subject of the prior judgment, defense had every opportunity to recall Joanna Reyes onto the stand during punishments, which they chose not to do. And, if they consider it our duty or their duty, the fact is that their client was the one that was facing 5 to 99 years of life, and they could have called back Johanna Reyes and questioned her on the subject, and they chose not to. That fact does remain there, Judge. So that's the state's position on it.
Judge, I have just one more thing. Closing arguments are just that, arguments. They're not evidence. And the jury was instructed about that multiple times. And so that would just be another argument regarding that.
All right, with regards to point two, the motion for new trial will be denied with regards to point two. All right, thank you.
May I be excused, Your Honor?
Yes.
I guess, well, we don't need the other, I'll be filing an amended notice of appeal to include the denial of the motion for retrial.
Sure.
Mr. Hunter further argued that the state committed a Giglio violation by misrepresenting the criminal history of Ms. Reyes and concealing the fact that she had violated her 2018 bail conditions following her entry of a guilty plea. Under Giglio versus United States, the prosecution is constitutionally required to disclose any agreements, arrangements, or information bearing on a witness's motive to testify favorably for the state. This obligation extends to evidence that a witness committed subsequent offenses while cooperating with the government, as such conduct is directly relevant to the jury's assessment of that witness's reliability and credibility. When the prosecution fails to disclose this information or affirmatively presents the witness in a manner that creates a false impression of law-abiding conduct, it violates the federal constitutional standard further refined in Napue versus Illinois, which prohibits the state from allowing materially false testimony to go uncorrected. In opposition, the prosecution argued that the defense had waived this claim under the contemporaneous objection rule, codified in Texas Rule of Appellate Procedure 33.1, by failing to raise a timely objection during trial. That rule requires a party to lodge a specific, timely objection at the moment the alleged error occurs in order to preserve the issue for appellate review. With respect to the state's closing argument, the prosecution further contended that because closing arguments do not constitute evidence, any improper remarks made during that phase of trial are subject to a heightened harm analysis under Texas Rule of Appellate Procedure 44.2, which requires the defense to demonstrate that the state's statements injected new and harmful facts into the proceeding that caused incurable prejudice to the defendant. Judge Boyd ultimately denied both grounds of the motion, determining that the state's conduct during closing argument did not legally justify overturning the verdict, and that the conditions under which the NCIC and TCIC records were provided did not rise to the level of a constitutional violation. As of the time of writing this video, Mr. Hunter has formally submitted the appeal to the Texas Fourth Court of Appeals, where the matter is currently undergoing appellate review. This proceeding highlights a fundamental tension in the legal system, the balance between the absolute requirements of due process and the strict disclosure duties of the prosecution. Judge Boyd asserted her power to sustain objections and enforce strict evidentiary limits in order to maintain control over the integrity of the trial, while Mr. Hunter resisted on the ground that the state's failure to properly disclose and accurately present critical evidence directly compromised his client's right to a fair trial. The clash also underscores why prosecutorial misstatements and disclosure failures are prohibited except in narrow circumstances. Such infractions, even if unintentional, create the appearance that the state may be manipulating the facts or that the defense may be unfairly blindsided outside the balanced adversarial process. By requiring full transparency and strict adherence to disclosure rules, the law seeks to preserve public confidence in the justice system's fairness. Comment below if there is a case that you would like us to cover. Thank you for watching, and don't forget to subscribe to see more case analysis.